Hi guys, it's Kathy. I hope you're doing well. I hope you recovered your strength after yesterday's marathon. There was a tiny clip yesterday in that trial where the judge played just a tiny bit of music. yeah, he screwed me. That was copyrighted material, so they demonetized my marathon. It's okay. I fixed it, but all the damage is already done. Darn judge. I should have checked harder. It's hard to see a piece of music, and I think I had 4 or 5 days worth of content. So this one is okay. This one is interesting. The defense for this one is very interesting. So we're going to go to Judge Blanco in Colorado. I love her. I do love her. To start with today.
Yeah. Okay, Daniel Hursta, 25N639, 25CR155, 25CR295, 24CR631. He's present before the court. He's in custody, and we are set for sentencing. And these are both Concord for probation if accepted. No, one of them is Concord probation. The other one is a 60-day jail sentence. Is that correct?
That's correct.
And that's 25CR631, 60 days of jail. Has he already served the 60 days?
Yes, the credit calculation is in the
Is accurate?
Yeah, it's accurate.
Okay. Do you agree, prosecution?
I do believe that in 25 CR 631, it said 52 days of credit, and it is a 60-day jail sentence.
Okay.
And I believe that counts credit towards the date of today's sentencing.
Yeah, that's right. Sorry, I misspoke. It says 52.
That's okay. So there's credit for 52 days in 25 CR 631, and that really does not have much for the court to hear argument on because it's pretty stipulated too. But what's really kind of the meat and potatoes for today is 25 CR 295, which is the class 5 felony. Accurate?
It is, and I'm not asking the court to impose a probationary term based on this. It's going to be about length.
Okay, all right. Then am I going to hear from anybody else other than potentially the defendant?
No.
And are there any corrections to the documents?
They're not.
Okay. Prosecution, any corrections?
No, Your Honor.
Your recommendation, prosecution.
Thank you, Your Honor. We are asking that in 25 CR 295, the defendant serve 2 years of community corrections with the 82 days of credit that is indicated on the PSI. We're asking for community corrections as indicated in the PSI. This defendant needs a higher level of structure, services, and accountability, and probation is not able to offer him that. And then on 25 CR 631, and getting a 60-day stipulated $1,000 drug offender surcharge with the 52 days credit. The other 2 cases have been dismissed or are going to be as part of the plea.
Your argument.
I read through this PSI, and something that really stood out to me, just because I do a lot of reading on strange topics, is that I think that until the age of 10, he was raised in a religious cult. Cornerstone Church is a church. There's one in Colorado Springs. I'm not talking about that one. There's one that started in like Queensland, Australia in 1978 and had offshoots all throughout the world. And it was a cult that believed in like extreme forms of corporal punishment, complete isolation from anybody outside the church for prolonged periods of time. Children were segregated from their parents. Children and families were moved overseas, which happened to him. I read through this, and what I think is that you've got a kid that has a lot of generational trauma that he's got to deal with. And I mean, I think the court can probably see that just reading between the lines. I'm not going to make a specific recommendation about the number because, quite frankly, I don't find the people's argument too offensive. I'd maybe go with 18 months instead of 2 years, but it's really neither here nor there since we'll know whether community corrections has worked What I am encouraged by in the PSI and in particular in the community corrections screen, if the court read it, is that community corrections is looking into getting him into specialized treatment as soon as he hits the door, which, I mean, the amount of trauma here is, I think, pretty astounding. And I don't know if this has been caught until now. And it's a shame that, you know, it takes a felony conviction to catch it, if that's in fact what happened, but hopefully he gets what he needs.
Mr. Gerstead, you don't have to make a statement, but if you would like to, this is your opportunity.
No, I think I'm good. Thank you.
Well, I did not know the history of that church, but I agree that there are things that you really were very vulnerable to tell the PSI writer, and I don't need to repeat them because you know them, and those are things that you're going to have opportunity to work on when you're at the halfway house, but those are things that you probably have to keep working on even when you're not at the halfway house, because a lot of people who should have been protective of you failed to do that from the sounds of it. And that has huge effects on us. And when we're hurting and when things like that in our foundations have had so much trauma, it's not surprising that you're struggling with substance use at such a young age, and that has been pretty disruptive in your life. What I found the most promising is that you presented as hopeful. You want substance treatment, mental health treatment, and even when your lawyer was speaking, you keep nodding your head. You are very intelligent. Your PSI, I don't often see when it says this is very well written. And so you're somebody who has a lot of positive things in how you're entering the sentence and maybe where you land when this is all done. ComCore is going to be life-changing for you if you approach it the same way you approach this. Court is going to order 2 years in community corrections. That's an appropriate amount of time, even for you to get the benefit, become hopefully non-residential and have some stability. And a reminder, if you're not successful, that transfers potentially to prison with mandatory 2 years of parole. So 2-year sentence could become 4. Don't walk away and leave ComCore. Follow through, please. Court will issue 82 days of credit for time served. This is, of course, in the 25 CR 295 case. And is there restitution prosecution?
I did check on that. One moment.
There will be no fine. There are fees and costs. No reconsideration under Rule 35B, as that's been waived. And certainly this will be concurrent with 25 CR 631. And the court is going to dismiss count 1. And while she's checking on that, I am going to dismiss 25 CR 155 and 25 M 639 pursuant to the global resolution of these matters. And the 25 CR 631 case, the court will honor the agreement ordering 60 days of straight jail time, crediting 52 days that have been served. The remaining 8 days can be served in community corrections once he's moved over there. There will be no fine. There are fees and costs, no reconsideration under Rule 35B, as that's been waived, no restitution in this matter. And the court is going to dismiss count 1 here in order to destruction of drugs and paraphernalia.
There's no restitution in the 295 case, and the court might be about ready to do it, but we'd be asking for the drug offender surcharge.
The 25 CR 295 case, the court is going to not order any restitution, making this a final order of the court. In 25 CR 631, you're giving me too much credit. There's a line at the top of the page that says the $1,000 drug offender surcharge. My eyes did not catch. I apologize. I know you even said that earlier. This will have a $1,000 drug offender surcharge. If he's making his payments, Mr. Goldstein, and gets to the closest to the end of the 2-year period and can't pay it, I would entertain a hearing at that time towards the end. But I want to see all effort made to pay the surcharge. There's no fine here. My hope is that you're going to be employed and stable and doing well, okay? Anything else from either party? Did we catch it all, Mr. Goldstein?
I believe so.
Okay, rooting for you. I hope you do well, sir.
Thank you.
Thank you.
So that was a first. That was a first. I was in a cult, Judge. Wasn't my fault. I grew up in this very bad cult from across the world. All right. This one's weird. Georgia.
Rebecca Irvin. I had it down for, this case down for a status conference. I don't have any other paperwork. Oh, okay. Ms. Irvin is here in case number 2019 CR 1050. And she had been on bench warrant status. Her case eventually made it to a dead docket. And Ms. Irvin's just recently been arrested on that bench warrant. So that's why she's here. So I wanted to have a status conference to see where we are and what we're doing.
I don't have
Okay, well, yeah, you got picked up and there was a bench warrant for you, so if you don't want to go to trial, I guess maybe we can close it out to some kind of plea. They want to know what, because this was an old case and on the dead dock for 4 years, so like where were you for the past 4 years and stuff?
Well, I've been working at Chicken House for 2.5 years.
Okay, so you just didn't realize that you had a
Yeah, I
bench
just didn't realize it.
All right. Your Honor, I believe that this is, after speaking with Ms. Irvin, that that this isn't going to go to, it's on the trial calendar. I don't believe this is going to be a trial. After speaking with Ms. Irvin, she did tell me that, she's been in and around the area. But, for the past 4 years, she just didn't realize that she had a case, and that was sort of the reason why, I guess, once you forget, in like 2021, it's pretty hard to sort of like gain back that memory. And
Judge, once you forget, it's very, very hard to remember, Judge.
getting arrested did jog her memory of this case, and so I would.
It usually
assume
does.
that we would potentially be closing that out.
You missed an Australian cult. Black something. I can't remember. Can't remember what it's called. Some kid was raised in an Australian cult, and that's why he's where he is.
It's not her intention to have a trial, so if a jury trial waiver needs to be filed, then I believe that's in working order, and that's what the plan is going to be.
All right. Let me do this. I'm going to continue her case off the trial calendar for next week.
Okay.
You're not ready for that. I don't think the state's probably ready for that because Ms. Irvin just got picked up. So she doesn't need to worry about filing a waiver or anything else. Y'all can talk about that more and we can deal with it at our calendar call. But Ms. Irvin's going to remain in custody until her case is resolved. So y'all can figure out how you want to do it.
Okay.
I would note that Ms. Irvin had a bench warrant previously on this case that was lifted. And actually entered her plea.
She already pled. She already pled to this case, guys.
So you might want to look at it a little bit. Because Ms. Irvin, looks like there's some indication that she had entered a plea, and it must not have gone through.
I think this is Hall County. I think.
I'll let y'all work through the, y'all can look through all the filings.
Yes, sir. Okay.
But Ms. Irvin, I'll continue off the trial week next week, and we'll address your case after that. You'll hear back on the calendar.
So your case is going to be continued, I guess.
No, Judge. No, that's not what I would have done. You need to find out if she pled. You can't hold her in jail if she pled. I mean, if she had a violation of her plea deal, then you can, but she already pled to this. Why is she in jail? Speaking of people in jail in Georgia that probably shouldn't be, I mean, probably should be, but maybe shouldn't be. Oh no. Oh, hold on. I don't, is this it? Never mind my last statement. I don't have that ready. Okay, this one, nothing exciting happens except. Okay, here's what we see. Indiana, all right? We're in Judge Glickfield's courtroom. It was my first time catching Judge Glickfield, all right? Nothing exciting happened with all these people. So you're not going to see a Judge Glickfield clip. But right in the middle of her docket, this happens.
Ms. Jacobs, you want to do this for?
Yes, ma'am.
All right. We're going to switch out for just a minute, guys. We have a special judge case.
All right. State here is Johnny Gray Keith. Come on, you have the seat table, Mr. Keith. This is State of Indiana versus.
It's Judge Jacobs, which I show sometimes. He's very strict. He's very harsh. He's very, I don't know. I don't know if he's military, but that's the word that I'm going to use. He's very military. He's very strict. And right in the middle of, so this courtroom doesn't look anything like his courtroom. So there was I had no way of knowing that they were in the same building or near each other. But Judge Jacob comes.
2504F6482, just listed as Johnny Keith here. Have we covered, were you here for the basic rights? Judge Glickfield?
Yeah.
Any question about your rights, sir?
No.
All right, we will enter denial of the allegations and set up the dates, the court's circuit 3 dates, and what dates we given?
I'm sorry, Judge.
Yeah.
We're gonna do you want me to just say them out loud?
Yeah.
Okay, we're gonna do a pretrial conference on July 22nd.
Before we go too far, Leslie, Mr. McKeith is asking to file a.
So we've seen her before, but I don't remember in what courtroom. So I'm thinking we've seen her in Judge Jacob's courtroom. We've seen him before, but he doesn't have his robe on, so he looks way, way, way different. Geez. Geez, I can't remember if we've seen him before. He kind of looks familiar, but I don't know.
Fast and speedy request, so if you want that in writing, I'll get that done before I leave this afternoon.
All right, before we do any of that, Dan, what's the state's recommendation on bond today?
Judge, considering the allegations as well as the nature of the charges, pretty lengthy criminal history, Judge, considering it's for intimidation, F6, we'd ask for 5,000 full cash.
Thanks, sir. Mr. Abel, what's your response to the bond request?
Just 1 second, Judge, just got bounced out of Odyssey, I apologize.
And we had a tough time over there today.
Do you require that to be in writing before you give new dates?
No, because it's effective anyway, so just based on that. Because you just want to waste it.
He looks smaller without his robe on. He looks much tinier.
Judge, I think my response to that would be, he was initially summoned in, sounds like the address may have been some problems with service. He's now here today, not too far back. I don't know that anything has changed given the state's allegations regarding the nature of the offense between when the summons was initially issued and today. I think the issue now is going to failure to appear or flight risk. Mr. Keith, if you were to be released, what town, what's your
mother town? They said, well, 6 South Dogwood Drive, call 98 and
I think we pretty much knew what town, yeah. I think we all knew where you live anyway.
yeah, I mean,
Mr. Abel, I'm going to release Mr. Keith today. The allegations and the charges, Mr. Keith, is that you made a threat to do harm to some police officers. I take that very seriously. The threat was not made directly to those police officers. So I'm not going to hold you today. I'm going to tell you this. You are to have no unlawful contact with any of the police officers in Charlestown. You don't go up and talk to them at random, even if it's just Founders Days this week. You walk up and say hi. That's a violation of the no contact order condition of your bond release today. Now, of course, if you need to report a crime, you're welcome to report a crime. But while you're enjoying the festivities this week, if you just walk up to any of those officers and say, hey, how you doing? That's a violation of your release today. You understand that?
yeah.
So just don't have any contact with those officers whatsoever. Now, if what you did, if what they're saying you did meets all of the elements of a criminal offense, that's something that sends you to prison.
Yeah.
I'm not sure where we are with that case, so I'm not going to pre-trial. I'm not going to hold you on a high cash bond today. But don't think that means I'm not taking these allegations seriously. If the state proves their case and the jury convicts you of it, I'm going to send you to jail on those cases, on those allegations. All right, so be released on your own account. And Brian, we don't have an early trial issue then, so we standard dates.
Standard dates, Judge, and I don't know if we talked about counsel yet or not.
Mr. Keith, you want me to appoint the public defender's office?
Yes, Your Honor.
I will appoint the public defender's office.
And Judge, just for clarity's sake, regarding the NCO, is that specific officers mentioned in the allegations or all of the Charlestown PD?
It's all the Charles. I believe one of the allegations was that he just take out all the Charlestown people. So we're going to no contact with any police officer.
I love this camera setup. Normally, I don't like it. I don't like these because they move around so much, makes you dizzy. But this one is doing a really good job. Look at that. Look, you can see everybody clearly except for poor Judge Glickfield. You can't see her at all.
Okay.
Please.
Okay, pre-trial conference is July 22nd at 1:30. Omnibus is August 25th at 1:30. Final pre-trial conference is September 2nd at 9:30. Jury trial is September 25th at 8 a.m.
Okay, we'll get a copy of these when I get released, Dave.
Yes.
And Ms. Keith, you're required to be in person. Is that right, Judge Whitfield, for everything?
Yes.
In person for all those. If you miss one, you've already missed the initial hearing. Whether there's an excuse for that or not, I don't know, but we're not going to give you a second shot to miss anything. So, if you miss any of those court dates, then warrant the issue, your bond will be $10,000 until we're done.
Yeah, we'll miss them.
All right.
Thank you, Your Honor.
He ain't joking. He does not joke. If he says, if you miss one, your bond's going to be 10,000. His bond's going to be 10,000, maybe even more. Okay. So I had this clip before. And I told you guys I wasn't ready to play it. And I don't know what's going on with this case now. I don't know if it got any further. I suspect not, because everything in Georgia, man. So this one's a hard one, because if the allegations are true, then she's exactly where she needs to be. And, she's not going anywhere, so it doesn't matter how long they take. If the allegations are not true, wholly breaking the Constitution in a billion pieces, cow. Holy cow. Like Georgia, so there's these inmates. I shouldn't even say this, but okay, there's these inmates in Georgia that are like 17 months in jail without even being indicted, without even knowing what their charges are. They don't even know what their charges are. They haven't been charged. 17 months, they're still in jail, haven't been charged. Now, for Georgia, I mean, that's almost nothing. We know people who, haven't been indicted in 600 days, 800 days, blah, blah, blah. Especially when we were watching Judge Mannon's docket. So she would take a list of these names when she got them, of people who were there for years without being charged. And then she would send them to the, she would send them higher up. Can't believe I can't remember her name. I cannot believe I forget her name. Anyway, in Georgia. So we've seen it, but it's just unbelievable that they could just pick me up and put me in jail for 17 months and never tell me why, never charge me with a crime.
Is that,
again, if she did it, then okay, I get it. But, I don't know. I don't know if she did it, but we didn't have a trial. We didn't even get charged yet. Where is she? This one. It's this one. So it's not just this one. There's like 7 of these ladies, or 4 of these ladies. I'm picking a number because I think I've seen 4, and I think there are more. Hold on, I want to back it up a sec. There we go.
wait a minute. Oh, there we go. Number 7. There we go. What's that? Letter Q. All right, let's get on the record. This is case number 25R127Q, as in Quebec-MJ, State versus Mindy Jane Forom. That's you?
Yes, sir.
I'll note for the record that Ms. Forom is seated at council table with her attorney, Ms. Sarah Riedel. Ms. Forom, your case is before me today on a bond issue. And by the fact that we're all sitting here to start a hearing, the state is opposed to bond. Is that correct, Ms. Stanley?
Yes, Your Honor.
All right, go ahead and give me your reason.
Yay,
And then I'll hear
thank you,
from Ms. Riedel.
CJ. Thank you.
Yes, Your Honor. As I have put on the record previously, this defendant wouldn't be entitled to bond because her case is indicted. The 90-day rule wouldn't apply. As far as Ms. Forom goes, she is charged with 3 counts of racketeering activity, trafficking, multiple counts of gang activity.
And I'm wrong. It's fine. It's fine. The other ones weren't charged. The other ladies in this pile were not charged with anything. They're just sitting in jail. But apparently her charges went through.
Possession of marijuana with intent and multiple counts of criminal attempt. As I stated previously, under the gang statute, which is 1615-4, that does require increased bail for the gang charges, as well as the special conditions that they should not have contact of any kind or character with another member or associate of a street gang. If the court is inclined to set a bond, I would also ask the court to set it at no less than $300,000 with the special gang conditions and the special condition that she be banned from DOC properties. I have had a chance to look, and just to put this on the record like we did with the last one, her PI case we actually came before you on January 17th of this year, it looks like, and we had a bond hearing. At that time, you said a $250,000 bond.
I am sure we got that. I am sure we showed that. I am sure that we've seen her before.
Those charges look to be trafficking, possession of ecstasy, 42,518, looks like possession of marijuana, possession of tools for the commission of a crime, and then another count of 42,518. So as I had just stated, the state's position is that that 250,000 could apply to this now indicted case, but we would just need to set a bond on the charges that she does not have a bond on. And I also have had a chance to look at her history. In 2010, it looked like there was given false statements to law enforcement. Again, without getting into the facts other than what's necessary for this, this is a situation where Ms. Forom and the co-defendants were part of an enterprise who is illegally smuggling drugs into Telfair State Prison. And so for those reasons, I believe that she would pose a significant risk to commit other felonies. And due to trying to get the drugs into the prison, I believe she would pose a significant threat or danger to the community. So for those reasons, we would be opposed.
Ms. Riddle.
Judge, I was pretty animated when I was here before because this to me is just ridiculous. My client has been in jail for 17 months now. She was in jail for 16 months before she was ever even indicted. And now she's indicted on charges that we didn't even know about and still don't know about because we have a sealed indictment. So I want to put it on the record. We need the indictment. I think we're entitled to this indictment, and the court needs to get this indictment released to us immediately. It's kind of hard to sit here and argue a bond hearing, but I don't even know what she's charged with, but I want to laugh when we're talking about gang charges. I'm looking at my client, and I think this is hilarious. I mean, it's serious charges, but ridiculous. This is as close to, and I don't have the law on this at this point, it's just because I didn't prepare for this exactly, but it looks to me like that this is what you would call prosecutorial indictiveness, prosecutorial vindictiveness, and vindictive prosecution. When I was here in January, we argued that it was crazy bond of $250,000 because this lady has nothing. And as the court knows that the law is clear that a bond that is beyond the reach of a defendant is as if they have no bond at all. And there's all sorts of constitutional issues being, to me, being breached in this case. I mean, my client now, after being in jail for 17 months, we still don't know what the charges are. We don't know what the basis of the charges are.
See, so I don't know. Listen, I don't know if her crimes are what they say it is. She's not going anywhere. She's going to be in jail anyway. Pity pat, no. But if they're not, this is really bad, really, really, really bad. And this is Georgia, and this happens often in Georgia. We see it all the time.
The severity of the charges have obviously been increased. It's basically a denial of her constitutional rights to sit in jail for this long. And we're unable to give this client a fair proceedings in any court of law when we have this kind of prosecutorial conduct. It just appears to me that in 17 months, while a lady is sitting in jail, it should have been known well before then what her charges should have been. And to have her sit in jail this long and then suddenly change it, and now she's apparently on indictment with I don't even know how many charges. I mean, I guess I could count them, but it's a whole bunch of them. And of course, we haven't had the ability to read them. I had filed a motion to reduce the bond previously because when I called to find out whether or not she had been indicted, of course, we didn't have an indictment because it's sealed. So I was told no, or my office was told no. So we asked to reduce the bond, which is what this court had agreed that we could do immediately upon no indictment. So then we get to court and learn that, yes, there is an indictment, but you can't see it because it's sealed. It just seems to me that I understand that we have to protect law enforcement. I get this, but we have to protect constitutional rights of our defendants. And I don't think we're doing that in this court right now. I'm pretty frustrated with this. I know that this is not the trial in this case, but we go on what the state gives the court a recount of what the charges are, as if they're what is the truth in this case. And so I think that the defendant should be given that same ability. My client, we don't even know this person, Antoine somebody or another, who had the drone and who where all the drugs and all of this stuff was for. Antoine Hurst. We don't even know who this person is. I don't even know where this person is from. Probably Atlanta or somewhere. We don't know. We don't even know who he is. He just, it's unfortunate if you happen to own property or be on property that's close around where people shoot off drones or fly drones, whatever you do with them. It's unfortunate when you find yourself in that mess. And she's not the only one that's back there in a jumpsuit for this same reason. But I understand that we're not here to try the case. I get it. But we're going to be here to try this case really soon because this defendant is going to demand a speedy trial the next term of court. This is outrageous that she has been in court this long. So we are certainly asking for a bond. We're not.
After 17 months, the lawyer says, okay, we're going to demand a speedy trial. Where were you 16 months ago?
We're asking that the bond that she had be reduced because she couldn't make that bond if, well, she has nothing because she's lost everything she had because she's been in jail for now 17 months. But before she lost everything, she couldn't make that bond if she sold everything she had. So it is actually the same as no bond at all.
All right, Ms. Fordham, there's a couple of things I want to get on the record. And after listening to Ms. Riedel, I remember back in January, I'm going to repeat a lot of what I told you back then, is that today is not the trial.
Yes,
On
sir.
a bond hearing, the court is required to consider essentially the 4 factors for a bond. And
So yesterday I was streaming for so long that I ignored my cats. So when he hopped up on my desk right now, I thought, okay, enough is enough. I will pet him for a little bit. I will go ahead and I will pet him for a little bit. He's the one that breaks my heart because the last owner declawed him. Oh, so I let him do anything he wants. He's treated like a king. And then he does that to me, and he does me dirty right when the judge was speaking.
And we've gone over these before, but prior convictions is one of the factors. Apparently, you have no prior felonies at least. And Ms. Riedel makes it very clear that you are not any sort of a flight risk. You wouldn't have anywhere to go even if you wanted to.
Yes, sir.
So that doesn't appear to be an issue. And you heard the state's position is they seem to have the position or the feeling that you might violate some of those bonds or be a risk should the court grant you a bond, or at least put a bond with a number on it that you could post. Now I've got to factor all that together and make a decision
Yes,
about,
sir.
at Ms. Riedel's request, whether to reduce your bond or set a number at which you can actually post. And as I sit here right this second, I don't know what I'm going to do.
Yes, sir.
As you can plainly see, I've got other people to attend to. And once I get through with it all today, I'll sit down and gather up my thoughts and make a ruling. Now, the other issue about the indictment, Ms. Riedel, is I know you sat through the previous hearings. I want you to brief it as well. As Ms. Riedel has said, Ms. Fordham, she is very animated about this, and well, that's fine. I'm glad to see it. You got a zealous advocate on your part, and that's exactly what you need, because these are very serious charges, as I'm sure you know. Ms. Riedel seems quite confident that you've got a lot of things going in your behalf for trial. And if that's where we go, that's where we go. But Ms. Riedel, I want you to brief it. Everybody's going to need to do their job on this case. This is a high-profile case. It's already getting a lot of attention. And I'll make a ruling after you get your brief in on the releasing the indictment, or at least portions of the indictment. So that's going to be it for today, Ms. Fordham. I'll notify Ms. Riedel in writing of my decision. Thank
Yes, sir.
you. You are
Thank you.
excused.
Thank you.
Any other business, Ms. Riedel?
No, sir.
All right. Well, you're excused if you want to leave, but you're welcome to stay. Okay. Ms. Cameron and Mr. McLaughlin, do you want to do yours separately or two at the time, or how do you want to do it, Ms. Cameron?
I don't care. I just want to do it first.
Who is it, Ashley?
I don't care. CJ, what's his name?
Williams.
Courtney Collins is the first one.
Okay.
Oh, okay, never mind. I ain't got that first.
Okay,
My list
then
says you have.
I think I need help with this next one. I don't know where we stopped yesterday. I actually have no freaking idea where we stopped yesterday. None. Did we see Faust? I don't remember her, so we'll go here. And if we've already seen it, let me know. I might not remember because of yesterday.
Report to pretrial services within 7 days of his release. Good luck, everybody.
We did see that.
I believe that's now 14 Gregory Richardson.
Okay. And if I'm stopping anybody from having their lunch, y'all just eat in front of me, because I was trying to, because I know everybody wants to leave early. And I got permission to leave the basement early today if I get through the calendar. If not, I got to stay here. So, all right. Who's got Mr. Richardson?
I don't think we did Richardson. I think we're good. I think I got started at the right spot. But if I'm wrong, let me know. If you didn't see yesterday's marathon, this judge is amazing. He's so good. He is just, so we have 48 minutes left of him, and then we don't have any more. And I don't know if I'm going to be able to get him again. I think he's pro tem. I think he hears cases for the Supreme Court now of Georgia. So, he's just so funny. Hi, Curtis.
That'll be me, Judge.
All right.
All right. Mr. Richardson is charged with armed robbery, possession of 2 counts of possession of a firearm during commission of a felony, and aggravated assault. He was arrested on June 12, 2025, which is the same date as the incident. He has no bond, as this is a bail restricted offense at first appearance, and was bound over to Superior Court. This happened in a residence, it appears, in Brookhaven, Georgia. So on June 12, 2025, approximately 4 a.m, officers went to the location after a woman called 911, said there's 2 men armed with guns outside her neighbor's apartment. As they arrived, officers saw a silver BMW speed out of the apartment complex with several hooded individuals inside. That car was detained given the circumstances because police believe they might have been involved. So they did a Terry stop on the car. This was occupied by this defendant and two others. They indicated they had just dropped off 2 friends at the incident location. When asked if there are any guns in the car, one of the co-defendants advised officers there were guns underneath the 2 front seats, and the 3 were detained while other officers continued to the incident location. The officers met with a 911 caller. They said that she heard shouting outside. She checked her Ring camera. She saw 2 men brandishing guns outside her neighbor's door. The caller was able to provide the police with multiple videos. The videos showed this defendant and the co-defendant who told the police where the guns were knock on the door of apartment 1214. The door opened a little bit. This defendant and co-defendant backed up, pointing guns in the direction of the door. They tell the woman to come outside, and one of them says something to the effect of, "I don't care." And then one of them actually readies and cycles around into the gun on camera. The woman, the victim, asks, "Why are you going to shoot me?" Officers are able to eventually speak to that woman, who said that earlier that night, she and the defendants she and her friend were picked up by her friend's friends, which were the defendants. They all went to hang out in downtown Atlanta. They drove the victim to her boyfriend's apartment, which is the incident location. When they arrived, the defendants demanded money from Johnson for the ride, but the victim refused to pay for the ride. After they closed the door in their face, the defendants called the victim, demanded they send money over an electronic app, threatened to shoot Thomas or the victim if she did not comply. When they did not comply, this defendant and the co-defendant showed.
I don't ever remember that coming up. Could that be part of another county? Any other county?
Outside the apartment, pointing guns at the victim while demanding money, and would not leave until she sent $100 via that online money transaction account. And that's when the defendants left. And so they also spoke to the friend who corroborated the story. This defendant has no criminal history. I will say that the other third person in the BMW that the police pulled over, that was actually the driver, and the driver actually said that they were told to wait outside while this defendant and his co-defendant went to the door to demand the money. This defendant has no criminal history, but given the brazen circumstances and the apparent near execution on camera, this defendant appears to be a danger to the community, and therefore state opposes bond.
All right. Is it Miss Faust? Is that how I pronounce it?
Yes, it is.
All right, be glad to hear from you.
Hi. First, I want to make the court aware that Mr. Richardson's co-defendant in this case, Kadarius Hutchins, was granted and posted a $25,000 bond with the conditions of a pretrial services, no contact with the alleged victims and co-defendant, and no contact with the victims and co-defendants, and not to return to the incident. And that was on July.
Well, I got bad news for you. You should have been in front of that other judge. Because I got to tell you, going to somebody's house at 4 a.m, putting guns at people's faces and demanding money, that's not the way my Lyft or Uber driver works. But you go ahead and tell me some more. But right now, you push it. So where are you in law school?
I'm at Washington and Lee in Virginia.
Virginia. Oh, man, what a great school. That's where my brother-in-law went to undergraduate. What a great school. But at some point in time, aren't they going to change the name just to Washington?
I have no idea. They fought us on it.
Yeah, well, it ought to be. But anyway, that's just me. Go ahead.
On to the Ayala factors. Mr. Richardson is 18 years old and has lived his entire life in the Atlanta area. He currently resides in Stockbridge, Georgia, with his mother, stepfather, and 3 siblings. In terms of community ties, his mother, Miss Letitia Richardson, is a caregiver for the elderly, and she has provided a character letter to the court attesting to his good character and close relationship.
I saw that. I read that.
If granted bond, Mr. Richardson will reside with his mother and has a stable and supportive home environment awaiting for him. Before his arrest, he was working 2 jobs. He was employed at the Department of Human Services, working 4 a.m. to noon, 5 days a week, and with the Food Depot, working 5 p.m. to 10 p.m., also 5 days a week. Additionally, he was enrolled in an online GED program through Southern Christian College for approximately 3 months prior to his arrest. He hopes to return to this once he is released. And in light of all the mitigating factors, including Mr. Richardson's youth, consistent employment, ongoing education, strong familiar ties, and no prior arrest or convictions, we respectfully request that the court set a bond of $25,000. And because of his age, this will be his mother posting this bond.
Well, it's good to have a mother. That's all I can tell you. But so Mr. White, is it true the other co-defendant, the gun-toting co-defendant, got a $25,000 bond?
I have no reason to discredit that. I wasn't
Okay.
aware of that, Judge, but I don't know the conditions or what other his background or anything else.
It is, Judge, just so you know, I pulled it up while Ms. Faust was speaking. It was $25,000 with pretrial services within 48 hours, no contact with co-defendants and victims, and do not return to that address.
Does anybody know, did this defendant have any relationship or know the victim prior to this alleged incident?
This defendant and his 2 other people in the car were friends with the victim's friend.
Okay. So didn't know this victim, but were friends with her friend.
Correct.
I presume it's a her. Yeah,
Yes.
It sounds like, yeah, okay. Well, $50,000 bond. He does not return to DeKalb County except to meet with pretrial services. He is to work full time. And if he's not at work, he has a curfew from 11 p.m. to 6 a.m. unless he's at work. He's not to have any weapons. I know you said he was working 2 jobs, all that, but it probably didn't make him too tired to be able to go up there and act like, I don't know, allegedly, because armed robberies are 10 years to the door. His age doesn't mean much to me, okay? Although we know that people's prefrontal cortex, especially with men, are not developed until they're a little older, but stupid conduct, if any of this is true, and it's dangerous. But anyway,
Judge,
yes, ma'am.
could I just request that the do not return to DeKalb County also have an exception for meeting with his lawyer?
Oh, yeah, I'm sorry. Yeah, meeting with, I'm sorry, yeah. Except for, yeah, do not return except to meet with pretrial services or any legal matters, including meeting with his lawyer. Because I'd hate him come to the DeKalb County Superior Court and all of a sudden he get arrested for violating the. Of course, years ago, I had a client who was banished from my county, and he got arrested because he was working with a cleaning crew, cleaning the probation office. And one of the probation officers happened to be working late and saw him. Now, I just thought that was bad all the way around. Luckily, I got him out of jail. But anyway, so yeah. All right. Good luck with
Judge,
school. What else
can you
got?
repeat the start time for the curfew? I think I missed
The curfew is what did I say? 11 or 12 p.m. We'll just say 12 p.m. to 6
11
a.m.
to 6.
Yeah, make it 12. Nothing good happens after midnight. And I think this happened at 4 a.m., didn't it?
Yeah, it did.
You can always put in any order I do. Nothing good happens after midnight.
All right, Judge.
All right, thank you. Good luck.
Thank you, Judge. May I be excused?
You may have a nice 4th and good luck with school.
Thank you.
I hope you do better than I did.
Going to Noah Stone, position number 20.
Okay.
Noah Stone is charged with aggravated assault and battery. This occurred June 3rd, 2025. He was arrested the same day. This was bound over to Superior Court only based off the criminal history. It appears at felony first appearance, he does not have a bond. Officers investigating an assault complaint. On scene, they spoke to the defendant, the victim, and a witness and discovered that victim and defendant live at the property together. However, the defendant lives in an RV behind the victim's home. On the incident date, the victim and the defendant got into an argument which showed when the victim saw the defendant cutting down a fence that was built between the RV and the house. As the victim confronted the defendant also made a disparaging remark about the victim's wife. During this argument, the defendant went inside his RV, retrieved a hunting rifle, and fired it at the victim. The victim was not struck, but a struggle for the gun followed, and there was a physical altercation during the struggle. The victim was struck twice on his head, and the defendant bit the victim on his shoulder. And also, the victim sustained injuries to his hand, which at the time they did not know if it was fractured or not. Officer did observe bite marks on the victim's shoulder. So, this defendant has a 2001 obstruction, DUI, fleeing and eluding at Gwinnett. Has a failure to appear in 2002 and a violation of probation in 2002. He has felony obstruction and DUI in 2001 out of Floyd County, 5 years to serve 12 months. 2005 says terroristic threats, but he was sentenced to 7 years to serve 4 months. There must have been additional charges. I guess that could have been 10 years. So it's felony terroristic threats, judge, in Gwinnett. 2007, 2 counts of misdemeanor battery out of Walton, 12 months probation with probation violations in 2008. Also had a probation violation in 10 for that prior terrorist threats. 2008, he was convicted of an escape out of Walton County, 12 months confinement. He has 2013 felony fleeing, driving with license suspended, interference with government property, 3 counts of obstruction, DUI, aggravated battery on a law enforcement officer out of Gwinnett. He sentenced to 5 to serve 1 with a substance abuse and a probation violation in 2017. Has 2017 possession of a firearm by a convicted felon and giving false information in Fulton.
Yes, I did.
5 years confinement in 2017, including a failure to appear in 2021. And then that's his criminal history, judge. We spoke with the victim. He said that he was some further background is that he lived at the location. A mutual friend requested the defendant could park his RV in the back of the victim's house. The victim allowed the defendant to live on his property. However, the victim said the defendant often uses drugs and probably used drugs on this date. Does not want to return, does not want the defendant anywhere around him, does oppose bond, but if he's granted bond, doesn't want him anywhere around him.
So he have to go over there to get his RV out. I guess it's movable.
Yeah. I guess we can address that if a bond's granted, judge. But
so what's y'all's recommendation?
Given his criminal history, the fact that I'm willing to accept that drugs were a factor, but it's a double-edged sword when it comes to y'all factors, because while it mitigates culpability, it increases risk of reoffense. And also, if he shot a hunting rifle at the person whose house he was staying at, who allowed him to stay there, this is he's got multiple violent convictions. He's been in prison for violent convictions. He's attacked police officers. He's a risk to the community, risk to reoffend. He has failure to appear as probation violations. He's a risk of failure to return to court, and therefore, and he's a risk to influence and intimidate the witness on this case. So the state requests bond be denied.
All right. How old a fella is he?
He was born.
He's 45, judge.
Okay. Well, he's past the age of stupid. All right, go ahead. What you want to tell me, counselor?
Thank you, Judge. Well, first I'd start off by saying I think the only evidence that there may have been drugs involved is conjecture by the alleged victim here. So if that's something that's of concern to Your Honor, I would ask that it not be considered, given that it's just speculation at this point.
The drug thing is not a concern to me. All his other activity is, but the drug issue is not.
I understand, Judge. I do also want to emphasize, as far as the facts, that the item involved here, the rifle involved, is a Benjamin Bulldog 357 air rifle, which is not classified under federal law as a firearm. It operates using compressed air rather than gunpowder. So while it is technically a hunting rifle, it is a high-powered air rifle and is fundamentally different from a traditional firearm. And
I understand that. I know that, but it still can cause serious injury.
I completely understand. I do think that it is an important distinction, however, and did want Your Honor to be aware of that.
Yeah.
Judge, Mr. Stone was born and raised in DeKalb County. He's lived in Georgia for his entire life. His sister, who is his closest family member, does live here. Unfortunately, his father has passed away and his relationship with his mother is strained due to some mental health issues, but he is very strong, does have very strong ties to the community through the fact that he's lived here forever and does have that relationship with his sister. At the time of his arrest, Mr. Stone was working with the alleged victim doing plumbing for about 4 years, which is about the same length of time that the two lived on the same property. I do believe that this RV is movable. I understand that he does intend to take the RV off of the property if he is allowed to have one trip as part of his bond, and would take it to his sister's address in Stone Mountain. She has said that he can live there if there's a no contact order with the alleged victim. Judge, I will say, as a result of this incident, Mr. Stone is currently very injured. He has a broken tailbone, broken ribs, cuts and bruises, a broken nose. So he does have a lot of medical issues that he'll need to be able to address. He was taken to Grady at the time of his arrest and was there for 4 days before being brought to the jail. I understand that there is a somewhat significant history here. However, I wanted to emphasize that the last violent charge that Mr. Stone had was back in 2013. So it's over a decade ago. It does look like, although there have been a couple of things in the intervening time, most of his charges are from 2013 and before. So I do believe that Mr. Stone, with his strong ties and with, everything else as far as the mitigating facts and things like that, is a good candidate for bond, and we'd ask that your honor set bond as low as possible. The request from the assigned attorney on this case is a $3,000 bond based on his means. I understand if your honor is not willing to set that low, but I would request that your honor set bond in this case.
Guys, we only have 28 more minutes of this, Judge. Oh, I'm so upset.
Here's the problem I got. Were it not, I think the person that, you don't bite the hand that feeds you. That's all I can say. And it appears he's worked for the fella that he allegedly assaulted. You and I both know they're not going to indict him within 90 days. I'm not going to give him a bond today, but set this thing down because I think he has a risk to reoffend. I would suggest his sister go and get that thing. I don't know if an RV requires a CDL license or something, but somebody needs to go ahead and move that so when he is granted a bond after the 90 days, he won't have to go back over there. But right now, I'm not giving him a bond. And I'm sorry about his health situation. Hopefully the DeKalb County Sheriff can deal with that. And if not, get him a lawyer to deal with that. That's it. No bond.
Thank you, Judge. Next is position number 21, Patrick Terry.
Judge, Mr. Terry is charged with 1 count of theft by receiving stolen property, 1 count of obedience to traffic control devices, 1 count of fleeing or attempting to elude, 1 count of possession of marijuana less than an ounce, 1 count of hit and run, 1 count of aggravated assault, 1 count of failure to signal, 1 count of reckless driving, 1 count of possession of a firearm during the commission of a felony, 1 count of obstruction of law enforcement, and 1 count of possession of an open container while operating a motor vehicle. The theft by receiving, the fleeing, eluding, the aggravated assault, the possession of a firearm, and the obstruction counts are felonies. The other 6 counts are misdemeanors. The facts of this case are that on June 13, 2025, Avondale Estates PD received a notification that a stolen Dodge Ram entered the city limits. Officers located the vehicle at the intersection of Covington Highway and Lakeshore Drive. Officers observed the vehicle change lanes without using a turn signal, and a traffic stop was attempted. When officers activated lights and sirens, the vehicle began driving recklessly, speeding, and ran through a red light. Eventually, the vehicle turned into Exxon parking lot.
There was a bumblebee in the car, Judge. They had to. They were terrified because there was a bumblebee in the car.
Memorial Drive, and appeared to be using the lot to escape rather than to pull over. One of the officers attempted to get ahead of the vehicle and tried to block its exit from the lot. The vehicle then rammed into the patrol car and then fled out of the lot onto Memorial Drive. Officers caught up to the vehicle a little ways down Memorial Drive and saw that the driver was attempting to exit. Officers closed the gap and prevented the driver from leaving the vehicle. The driver ignored verbal commands to show his hands and exit the vehicle. Law enforcement tried to remove the driver forcefully, and the driver resisted arrest by tensing his arms to prevent handcuffing. Law enforcement noticed that he was reaching for his waistband, where a utility knife was clipped to his belt. The driver continued to ignore commands to stop resisting arrest and ultimately had to be tased before being brought into custody. Once in custody, the driver was identified as the defendant. An inventory search of the vehicle found
No,
half an ounce of marijuana.
I don't believe that part. I believe he resisted arrest. I don't believe for 1 second that he tried to pull a knife on cops around them who all had guns. That makes zero sense. That means you instantly die in that situation. So no, I don't believe that one part is too much for me.
A set of CubeSmart storage unit keys, multiple car keys and fobs, an empty bottle of Budweiser, 2 pairs of women's shoes, a check that was not made out to the defendant or drawn an account owned by the defendant.
Did you say 2 pair of wooden shoes?
Women's shoes, Your Honor.
Women's shoes. Okay, I thought we were gonna have a Dutch matter here, but okay.
No, Your Honor. 2 pairs.
Is there anything wrong with somebody having some women's shoes in their car? That's kind of an interesting.
Yeah, so I will. So it's 2 pairs of women's shoes and a Balenciaga purse. And the defendant was arrested and charged with what he's charged in this case. The reason the women's clothing and the purse is notable is that this case is being investigated further because there were a string of commercial burglaries at storage units in the area. So given that he had storage unit keys and expensive women's clothing, it's possible that it's linked to that. He's not currently charged with that in this case.
I just
I'm
was
noting
curious
because
if
it's
y'all
being
were gonna
investigated.
accuse him of something else. Okay.
Now, in terms of criminal history, the defendant was adjudicated delinquent for burglary, 2 counts of burglary in 2004, adjudicated delinquent of child molestation in 2005, adjudicated delinquent of carrying a weapon at school in 2006, adjudicated delinquent of obstruction in 2006, convicted for theft by receiving and theft by taking out of DeKalb in 2010, convicted of armed robbery out of Fulton in 2010, where he was sentenced to 15 to serve 10. Convicted of obstruction, driving while license suspended, out of Henry County in 2022. Convicted of aggravated assault, possession of a firearm during the commission, and obstruction out of Gwinnett in 2022. And convicted of theft by taking out of DeKalb in 2004. So given the defendant's criminal history, the facts of this case, the defendant poses a danger to the community, a risk to reoffend, and is a flight risk, and the state is opposed to bond.
All right. What you want to tell Ms. Akins?
Yes, Judge. So Mr. Terry has lived in Georgia for pretty much his entire life. He was born in Alabama, but moved here when he was a young child. So all of his immediate family lives here, including his mother and his brother, who he lives with. He would also be able to return to living with them once he's released, and they live in DeKalb County, so it would be right here.
Was he living with them when this alleged event occurred?
I believe so.
Okay, all right.
He most recently has been working as sort of a freelance handyman, but had worked at Chipotle prior to that through January of this year, but had before that had some issues having a steady job because his family's house burned down, and he had to take some time off of work to help deal with that. And he did unfortunately suffer some 2nd-degree burns during that incident as well. So he, doesn't have the most stable employment, but he certainly is, working and trying to have a steady job. He is registered to start classes at Georgia State on July 9th. So, we would very much ask that he be granted a bond so that he can continue that. His plan is to study business administration, and this would be his first semester of college classes ever. There has been some, go ahead.
Go ahead. I'll come back to my question.
Okay. There has been some history of some mental health issues and substance abuse as well. But he is very willing to get treatment for that. If the court were to order a mental health evaluation, he would absolutely comply with that. And we do plan to have a social worker be in touch with him to try to set up a plan for that. But we would ask that, given that he hasn't had steady work very much for the past few months, we would ask that a bond be set, but in the lowest amount that the court would be willing to set.
The aggravated assault, is that striking the officer's vehicle with his vehicle?
That's my understanding, Judge.
And then the hit and run would be the same. I mean, they're two different, but that's one of the misdemeanors, hit and run. Okay. All right. So we got theft by receiving. That's the women's clothing in the pocketbook.
I believe it's the car. The car was stolen.
The car was stolen as well. Okay. You got theft by receiving. What were the other felonies?
So for felonies, it's the theft by receiving, the fleeing or attempting to elude a police officer, the aggravated assault, the possession of a firearm during the commission of a felony, and the obstruction of law enforcement officers.
Okay. And the possession of the firearm, that was a knife, actually, right?
No, I am looking at that. I mean, looking at the notes I have in front of me, I believe it was the knife. I'm not 100% sure.
In his pants that he was trying to pull out. Okay. All right.
And he did let us know that it was actually a box cutter that was in the car. So
either way, they got a blade. Okay. So the most consistent thing Mr. Terry has done is the 10 years he pulled for the armed robbery. That's been the most consistent. So, but I'm going to give him a bond. You got 1, 2, 3, 4, 5 felonies. $4,000 on each felon, which is $24,000, and $1,000 each on the misdemeanor, which is a total of $30,000 bond. Be enrolled in school full time, or to be working full time, or a combination thereof. He has to live at his parents' residence. And if he's not working or having classes, he will have a curfew from 11 p.m. to 6 a.m. He's reporting pretrial services within 7 days of his release. He's in a tough situation. And I would suggest that y'all go ahead and get him some mental health evaluation, but I'm not ordering that. That's not a condition of bond. I wish him good luck.
Thank you, Judge.
Thank
Your Honor, that is my last case on the calendar. May I be excused?
You may. Happy 4th.
You as well.
Thank you.
All right, Judge, that brings us to Calvin Walker. He's charged with armed robbery. He's 17 years old, Judge. And he was at the time of the offense. This happened June 15th, 2025. Well, no, he was arrested June 15th, 2025. This occurred June 12th, 2025. He's got no bond, as it's a bail restricted, or it's a Superior Court only offense for armed robbery. This occurred at a BP gas station. So on June 12th, 2025, this defendant and 2 other individuals went into the gas station. This is all on video. One of the people opened the door and stood in the doorway. 2 other people walk in. This defendant, another individual behind him, armed with a handgun. One of them pointed a handgun at the clerk. The other ones collected a bunch of food and beverage items. He believed he knew who they were, as they had been there before. And so he told the police this defendant was found at an apartment complex nearby wearing the exact same outfit he wore in the gas station surveillance video. That outfit specifically was a pair of red Puma branded shorts, a black zip-up hoodie with very distinct white line pattern on it. That's how this defendant was arrested. He has 1 truancy arrest in 2022 as a juvenile. And other than that, that's the entirety of his criminal history. There's no contact. Judge, given the fact it's an armed robbery, the state is opposing bond as a risk to community and a risk to reoffense and a risk to influence the witness as he apparently knows the location. That being said, if the judge does, indictment's already been drafted on this case. We're just waiting for a grand jury date. I do anticipate that will be done before the 90th day.
Was he the one with the weapon, or was it the other one?
It is, from what my notes, it appears that someone else was holding the gun. He was just party to.
He's a co-conspirator, if you will. Okay.
Yes, Judge. If you now our position is no bond. That being said, if the court is granting a bond, we would want no return, no firearms, a curfew for him because he's 17 to be 10 p.m. to 6 a.m. And I'm trying to figure out if we have identified the co-defendants, Judge, because typically I would want there to also be a no.
Well, he can't hang around with the two Confederates that were with him. I mean,
yeah,
you call them co-defendants, I call them Confederates. It doesn't matter that.
Yeah, and that would be my request.
Ms. Babette, what you want to share with me?
Thank you, Judge. Before I launch in, Mr. White, my understanding was that the date of the incident was April 22nd of this year, but I know you said it was June 12th. Is that?
Yeah, I'm trying to look at those are the notes I have. I have no reason to just that's what the previous ADA mentioned to me. I mean, if you think it's April,
Okay. I mean, it's not
yeah.
too important. I just wanted to make sure I had the correct information. Okay. Your Honor, as stated by ADA White, Mr. Walker is only 17 years old. He was not the individual who had the firearm in this alleged incident. He is about to be a senior in high school. He recently completed the 11th grade and was enrolled in Orange Technical College. Orange Technical College is an online program arranged through Orange County Public Schools to help people finish their high school diplomas and earn a trade. He is hoping to eventually work in welding and does have ambitions to go to trade school after getting his GED. Mr. Walker does live in Florida with his grandparents in candor to the court, but he does have very strong ties to Georgia. He's been living with his grandparents for 1 year and was in Georgia to visit the rest of his family. His mother lives in Stone Mountain with his 3 siblings. So he does have not only the means to come to Georgia, but also the strong ties to Georgia, which I believe that although he lives out of state proves that he would not be a flight risk and that he would not fail to appear to court going forward.
Did he move to Florida with his grandparents because of discipline problems in the household, or mother wanted to get him away from some of his Confederate friends, or what?
I don't have any reason to believe that there would be any kind of history of issues between them, given that, or of discipline, given that he doesn't have a history other than that one truancy. The only information I have from his assigned attorney is that he moved to Florida.
I'm here, Your Honor. Sorry.
That's Ms. Walker, his mother. Is that correct? All right.
Yes, sir.
Now, before you speak to me, Ms. Babette, do you need to speak to her?
I would prefer to, but if I could just finish my argument and then I can take 1 minute.
And then if you need to speak to her, then hang on, Ms. Walker. Then we'll...
Yes, please come get these cats. Hold them for ransom. Yes.
We can. Your lawyer will let me talk to you. Okay, go ahead, Ms. Babette.
Thank you, Judge. As I was stating, the information I have is that he moved there a year ago to stay with his grandparents. I understand he helps them out around the house and helps, with the lawn work and things like that. His mother, Miss Walker, does work at Emory Midtown, to my understanding. I also have information that several character letters were sent to Your Honor. I'm not sure if you were able to read those.
I did,
okay,
thank
great.
you.
So just, based off of his extremely young age, the fact that it does not appear this is a pattern of behavior for him, the fact that he is not alleged to have been the individual with a firearm, and you know, there's been, to my understanding, at least some months that have passed since this alleged incident without any further issues on Mr. Walker's part. We would be asking that your honor set a bond no more than $10,000 on this case to
So
allow
did they
him
not
to-
take any, maybe I said, did they not take any money? Did they just get food items and beverages? Is that what y'all's report shows?
My understanding, yes.
That's correct, Judge. I'm reading the reports right now. This did allegedly occur June 12th.
Okay.
For the warrant and the police reports. And then they were found nearby while police were investigating another string of crimes that have not been linked to these individuals yet. But they were suspected of that. And then that's when they're like, wait, those clothing matches the clothing for the armed robbery. And that's why he
But
got
this
arrested.
is the items taken reflect juvenile behavior to me versus so okay, all right. Now, if you need to break out and speak to Ms. Walker or call her on the phone and we mute you for a moment, you can, Ms. Burbett, or
Judge,
whatever you go ahead.
I do have that Ms. Walker and the assigned attorney have spoken to my understanding, so I can let her just speak a little bit if she's still there. It looks like she
All
may.
right, she's here. If you will unmute yourself, Ms. Walker.
Ms. Walker, can you hear us?
She's her screen is frozen. So, Mr. White, while we're trying to get, now you go. Ms. Walker, can you hear us? Mr. White, or has anybody else been arrested in this matter?
I believe the co-defendants, that's what I'm trying to research because it's not listed in the note-taking document. There's a case number on our system. It probably, but I'm going to confirm that for you.
Okay.
Ms. Walker, are you able to hear us?
So while you're looking, Mr. White, I know y'all oppose bond, but I'm gonna give him a bond.
And Judge, it does look like Ms. Walker sent in a character letter herself, so I don't feel like it's, I don't think it's necessary to hear from her.
Okay, all right. So, I think Mr. White's trying to find out if
Yes,
there's a.
Judge. It doesn't appear that anyone else is arrested under this case number.
Okay, all right. Well, here we are. I'm gonna set him a bond, the amount of $15,000. He is to live in Florida with his grandparents and not return to Georgia except for court or for sanctioned family gatherings, which I consider holiday time. 4th of July, Labor Day, Thanksgiving, or Christmas. When he is in Georgia, well, he's gonna have a curfew from 10 a.m.
They built RBK in the same, like it used to be a morgue. It used to be a morgue. And it's Burger King now, and I will not. I just cannot.
p.m. to 6 p.m., whether in Georgia or Florida. He is not to return to the store where the incident occurred. He is not to possess any firearms. He must successfully complete either his GED or high school education while he is out on bond. Failure to successfully complete that indicate that he's not really that serious, and I can revoke his bond for that. So we're just going to help him out a little bit. I think that'll cover it for me, okay? I wish everybody good luck.
Thank you,
All right.
Judge.
So we're on our final position, Judge, position 23, Reginald Ward.
All right, so Reginald Ward. So we sort of went alphabetically, whether we intended to or not.
Oh no. Oh no, it's the last one, guys.
All right, who's got him?
Max Bierman for the state judge. Mr. Ward is charged with 1 count of felony terroristic threats. Now, this case is very new, and I wish I had more to go on, but I don't even have a police report at this point. All I have is the probable cause and the warrant. So what I can tell you is that the defendant and the victim were roommates, and that the defendant threatened to kill the victim in the presence of law enforcement. That's the entire factual basis I have. And this occurred on June 18th of 2025.
Threatened to kill while in the presence of law enforcement. So apparently law enforcement were called out to some scene.
Yes, Judge.
And may have been a fight or something, and while they're separating them, are they both males? Or do you know?
No, the victim is a female.
Okay. All right. So that makes it more of a domestic violence type charity. All right. Is it Ms. Go ahead. What's his history?
Yeah, in terms of criminal history, Mr. Ward has a conviction for burglary out of Fulton from 1979, a conviction for DUI out of DeKalb from 83, conviction for criminal trespass out of Fulton from 87, conviction for DUI out of DeKalb from 88, conviction for DUI out of Clayton from 92, conviction for simple battery out of DeKalb from 93, conviction for simple assault out of DeKalb from 94, conviction for criminal trespass and simple assault out of Fulton from 99, conviction for burglary out of 2000, out of Fulton in 2000, conviction for simple assault out of Fulton in 2000, conviction for battery out of DeKalb in 2003, conviction for battery out of DeKalb from 2005, conviction for simple battery out of Fulton from 2008, conviction for disorderly conduct out of DeKalb from 2012, and is currently on bond for a pending aggravated assault and home invasion out of DeKalb from October of 2024. So,
thank you. Thank you so much.
Much to go on by way of factual basis in this case. The defendant committed a terroristic threat in the presence of law enforcement while out on bond for home invasion out of DeKalb. So the state is opposed to bond, as the defendant poses a danger to the community and a risk to reoffend, given his criminal history.
So it appears that most of his stuff was just being a DUI and likes to scrap with people until this 2024 case. I mean, he had one other felony, and he hadn't been convicted of that. Has he been indicted in that October home invasion case?
I'm not going to lie. I forgot what day it was. That's why I'm streaming right now. I forgot it was Saturday.
I do not believe so. I think it is still
holiday weekend
at present.
Okay. All right. And so he's got to be mid-50s.
I believe he is 63, Your Honor.
He's 63.
Yes, Judge.
So at the time of the home invasion, he was eligible at 62 to be drawing his Social Security. Do you know anything? Do you know any facts about that? You don't know any facts about that, because I know that.
I do. I mean, I do have factual basis for the home invasion, if Your Honor would like to hear that.
I want to hear just a little bit. Don't worry, Miss Ballin. I'm going to get with you.
So the facts of that case are that on October 5th, 2024, Stone Mountain PD responded to an assault call at 5390 Rockbridge Road in DeKalb County. Upon arrival, officers made contact with the victim and two third-party eyewitnesses. The victim was inside of his residence when the defendant and other individuals that I do not believe have been identified forced their way into the victim's home and began eating.
I am kind of working today. I got a plan to, so a lot of my subscribers now were not subscribers earlier. So what I plan on doing is creating like a mini series every day, 10-minute video of cases from a while ago that I put on that no one saw, or they forgot that they saw. 10 minutes. It's going to be like a series because there's some really good ones back then that everybody missed. I really like. So, yep, that's what I plan on. That's what I plan on doing today. Starting that mess.
The victim with wooden sticks, metal poles, resulting in a visible gash to the victim's head, and the victim also reported losing consciousness. Officers went to a nearby area to look for the defendant in his room. It looks like the defendant was staying in a rooming home at the time. And according to one of the witnesses,
did the victim know the defendant prior to this incident?
I see that the two of them were in an argument moments before the attack. Moments before an attack prior to this. So I don't know exactly how they know each other, but it does appear that they do know each other.
All right. And so based on him having that charge pending, y'all, new charge, you don't want me to grant a bond. All right, Ms. Balin, what you want to share with me? Balin, not Balin, Balin.
First, I want to share he is 63, so, and he is currently getting disability for his I'm reading this, I might butcher this, deteriorating joints. He's had 2 shoulder replacements and now got knee surgery and working on his other knee. So the jail's conditions are not very helpful for his condition at the moment, as he's receiving most of his medicine, but not everything to help with the aching pains. Essentially, I understand that you have worries about his danger to his community because of his criminal record, but I do want to emphasize that he has a lot of community ties. He has told me that if bonded out, he would be staying with his sister in Decatur. I've called his sister and she has been nothing but supportive and said kind words. She has told me that he is a family man. He focused on happiness and togetherness, dependable, and he's always helping people, including a landlord that he knew that had cancer. She will also be staying in Decatur. She's willing to pay the bond. She's willing to be there, supportive. The only reason that she's not here today is she had work. He also has an adult daughter who lives in Valdosta with 2 granddaughters and a brother there. Like I said, he's not working because he's receiving this disability. So essentially what I'm saying is, even though he does have this large criminal record, he is not a flight risk, and he would most likely.
Let me ask you this.
Mm-hmm.
The alleged victim, were they in a relationship?
From what I heard, from what he told me, they don't seem to be in a very close relationship, like a relationship. I didn't even know they were roommates. He didn't tell me they were roommates. He told me essentially that she was banging on his door and wouldn't leave him alone, trying to get into his apartment. And
Okay.
he knows her sister, but the relationship between them, it's not a relationship.
Okay, all right. They just were they shared space in a boarding house or whatever. Okay, or roommates. All right. Well, if he's gonna live with his sister, and the victim doesn't live with his sister, does she?
No, she does not.
Okay. $10,000 bond, no contact with the victim, no return to that location. He cannot have weapons. That's it.
That hurts my feelings. Oh man, it's over. I don't have any more of him, and I don't know if I'm ever gonna get him again. Oh, David Irwin, you were great. You were amazing. Thank you for 2 straight days of greatness. We appreciate it. We hope to see you again really, really, really soon. All right, guys. I did set up OJ today, so you should just be popped right over. Thank you so much for coming out today. I really appreciate it. And if you don't go to OJ, I'll see you again really, really soon. Bye, guys.
Got these lights that close digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.